Viking lawyer's got a brew in hand, streaming wild cases across the land. A courtroom circus, a legal ride, slightly buzzed on justice and a Viking's pride. Objections flying, gales a swing. Nick just laughs, oh, what a thing. It's a slightly buzz Friday lore show, where the weirdest trials steal the show. Nick's got the verdict, he's got the flair, with a horned helmet and a lawyer's glare. Mugshots rolling like a movie reel, a pizza thief or a banana peel. He calls it absurd, he calls it wild. Your Honor, is this trial on trial? Raise your glass to the streaming king, a Viking lawyer with a legal zing. Don't sue me for fun, I'm here for the lore, and maybe one more drink before we explore. It's a slightly buzz Friday lore show, where the weirdest trials steal the show. Nick's got the verdict, he's got the flair, with a horn helmet and a lawyer's glare. Here lawyers glare.
Yeah. Hello, folks. Yeah, wrong intro. That's for tomorrow. Oh. Yeah, sorry. Hey, I'm here over at Rumble Studios because StreamYard, it's simply that bad nowadays, and I'm probably going to change over completely to Rumble Studios going forward, meaning that Rumble, but so which means I can't preload the things on YouTube, so it will just start. But hello folks. We are back on the Michigan Hyperbaric Chamber Explosion case. CEO Tamela Peterson was in court yesterday for an alleged bond violation. And just to set the scene here, Tamela Peterson, her and her alleged co-conspirators were arrested back in March of this year. She was put on a $2 million bond, and of course she could cough up that money. And but the conditions were standard things: home confinement, don't drink, do all the things, everything. And she's been whining ever since about, oh, it's so hard to be in her, I believe she lives in like a 5,000 square foot mansion. Oh, you poor thing. Oh, you poor thing. Oh. But, as it seems, she couldn't even stick to basic bond conditions. Now, her attorney has filed throughout the months about easement and can we please do this instead and stuff like that. So, yesterday was a hearing. I tried to do it live, but Judge cut off the live feed as it happened. But thanks to Click on Detroit, who were there and recorded it. So good on them. Everybody go over to Click on Detroit their YouTube channel and subscribe to them for local Detroit news. So thank you to them. Thank you to them. So, folks, here is the hearing. Now, this is more than just her alleged bond violation. This is more than that. So, yeah, let's just go ahead and have closed captions. And here we go.
2500876. This is the State of Michigan versus Tamela Peterson.
Thank you. Good afternoon, Your Honor. Chris Kessel for the people.
Gerald Gleason on behalf of Ms. Peterson, who's to my left.
Tamela Peterson.
Your Honor, Tom Kramer also appearing with Mr. Gleason. Thank you.
All right, thank you. You can have a seat. Today was the date and time that we had scheduled 2 matters. One of which is the people's motion to allow testimony pursuant to MCR 6.006. We also have on the docket today a bond violation hearing based on allegations that were previously raised when Ms. Peterson appeared here. I believe it was August 28th. And I understand we're going to start with the motion.
Yes, Judge.
All right. So I've had a chance to review the motion that you filed seeking the ability to allow testimony pursuant to MCR 6.006, which would be via video conferencing or Zoom. When we resume the examination date, I did get the response from the defendant. What, if anything, would you like to add to the record as for your motion?
Judge, really just more in response to some of the stuff Mr. Gleason wrote. First of all, it seems like of the 12 factors in 2.407, the only ones really at issue are number 2 and number 3, whether there is a specific articulable prejudice and the convenience and the cost. The defense essentially claimed that the only specific articulable prejudice that exists here is the denial of the right to confrontation. But the problem, Judge, is a preliminary exam does not have a confrontation clause right. The Supreme Court, the United States Supreme Court, has said that the confrontation clause is basically a trial right on numerous occasions. And the Michigan Court of Appeals in 2019 in People v. Olney, that's O-L-N-E-Y, based on those Supreme Court rulings, has said that, I'm quoting, "Therefore, while the rules of evidence apply during a preliminary examination, the right of confrontation does not." So there really is no specific articulable prejudice that the defense can point to. There's no need to do the buoy analysis that they asked the court to engage in. The only other issue, Judge, is the convenience and the cost as it relates to the importance of the testimony. Judge, we have to fly this witness out from literally across the country from California. I think we all know that things are moving very slowly in this case, and I think it's entirely possible that while I anticipate this testimony to be short, and maybe Mr. Gleason anticipates the testimony would be short, there are a number of other attorneys here who are using their time, using greater amounts of time, I guess, which is fine. But my concern would be, Judge, it may go into a second day, it may require changing plane tickets, it may require adding hotel reservations. And the truth is, Judge, the testimony here is not as important as the foundation the testimony is laying to allow for the exhibit, or the entrance of the exhibit, which is a manual. Maybe there are a handful of questions otherwise, Judge, but I expect on my end this to be very brief, direct exam, and when weighed against the cost of flying someone out and having a hotel and all that other stuff, Judge, I just don't think it weighs in favor of requiring this person to testify in person. So unless the court has any other questions, I don't have anything else to add.
All right.
Yeah, I agree with Mr. Kessel that there is not a confrontation right at the preliminary examination stage. However, there is one at the trial court stage. And my objections are twofold in this regard. One, the way in which the government is going about their case it sounds to be like a process of elimination, and it could only be the bracelet as per their expert. The witness at issue is the manufacturer of the entire hyperbaric oxygen chamber. And while they are utilizing that person for a limited purpose, that doesn't confine our cross-examination. And I would like to have the manufacturer come in and talk about their technology and satisfy the court that it's actually legitimate. The other concern I have is, as the court knows, under Michigan Rule of Evidence 804B, if a witness is later unavailable, they can use a transcript of a preliminary examination hearing at the trial stage. And I don't want to get bootstrapped by allowing a remote hearing here and then the Attorney General come to the trial judge at the circuit court, if the court finds it over, and say, well, we had a hearing already, so Seacrest doesn't have to appear in the future because they're outside of the subpoena power of the court. So my view is I'm not sure that Seacrest is willing to come, and that may be the reason for the motion. I think that Seacrest should come and be here in person because of the way in which the Attorney General is going about its case. And three, I want to object now to prevent the Attorney General from later trying to use Michigan Rule of Evidence 804 if the court allows the remote testimony. I want the record to firmly show that I object to it now and would object to the use of a transcript if we proceed that way at the trial level. Thank you.
Any response, since it is your motion?
Judge, only that, and I certainly respect Mr. Gleason's concern. I fully, and I've discussed this with others in my office, Judge, if need be, I am fully prepared to get in touch with prosecutors in California and get an interstate witness detainer when it comes to trial. When it comes to trial, I fully expect to have all of my witnesses, if there is a trial, of course, all of my witnesses present. This, however, obviously is not a trial, it's just a preliminary exam. So I appreciate Mr. Gleason's argument. I'll let him know and let this court know that I would fully be planning on having this witness appear in person if this matter does come to trial.
Okay, I appreciate that. I think that that's very helpful. I did, as I indicated, have an opportunity to review the motion. I should note, just so we're clear, and it may require a separate motion date being set on the matter involving Mr. Markin, because I think both of these motions were filed, one as it relates to Ms. Peterson and one as it relates to Mr. Markin. I don't know that there was ever a response that was provided as to Mr. Markin, and I only had information that defense attorneys on behalf of Mosteller and Moffitt had stipulated to the testimony being permitted via video conferencing. Is that correct?
It is, Judge. After those attorneys stipulated to it, I did have a conversation with one of Mr. Flood's associates, and he indicated that Mr. Flood would be stipulating to this as well.
Okay.
So I think that's why nobody's here or filed a response yet.
And so I think this motion date was actually set because obviously your motion was filed, but we had a very clear position being taken in opposition by defense. But if we need to address it as it relates to Mr. Markin, we can still do that. We have some time. Obviously, the people are relying heavily on MCR 6.006 and MCR 2.407 to support their request. There's an objection here, and I think it's important to have a record of this. I think that on behalf of Ms. Peterson, the issues that Mr. Gleason is raising are appropriate and probably a good idea to preserve the record. I don't know that they would lead this court to the conclusion that we can't consider this request for video conferencing. I am relying on the position that the people have taken that they believe that this testimony is necessary for their case at this point as it relates to a possible foundation for an exhibit being admitted. They've indicated that the testimony is not likely to be lengthy, at least as it relates to the questions that they will be asking on direct. I know that doesn't preclude the other attorneys from cross-examining the witness, but they'll have the ability to do that here. There's no confrontation right that attaches for exam, and it appears that Ms. Peterson is going to reserve her right to raise that issue again if it comes up, if the case proceeds to circuit court and then the trial beyond that, and that the people have indicated on the record that they don't have any intention of trying to maintain whatever the court decides as it relates to the exam testimony being the same as what they would attempt to present for purposes of a trial, where I do think there would be a valid argument as it relates to confrontation. Considering the factors that are outlined in MCR 2.407, clearly I think the court has the capability to have this person appear in this manner and provide testimony. Thankfully, I am very confident in the court reporter who will be maintaining the record and will be able to make a record of whatever is happening during the course of the exam, so that you have a record that clearly, I think, the convenience of the parties is a factor here based on what's been represented about the cost that would be attributable to bringing this witness in from across the country. And I think it's fair to say that the timing of the exam, at least to date, the length of time.
Yeah, this particular witness is apparently for the actual hyperbaric chamber. And because the manufacturer is not in Michigan. And so for this preliminary hearing that is in near future, he's going to testify remotely. And the defense is saying, hey, but if he by some reason can't testify in the trial, then the state can use his testimony for this, and we want to have him here for confrontation clause. But as the prosecutor said, well, he's going to be here. And yeah, the intent at least. Now, I would assume that if this person from the manufacturer can't be there, they have other people that can. I mean, it's not that hard, but I understand the defense. I mean, if they can make it harder for the prosecution, they would make it harder for the prosecution. Dave says, I do not like remote testimony during evidence hearings, but because the judge is the one making the decision, at least it's not a jury.
Time for the witnesses has exceeded the expectations of the court and the parties, so we can't be certain about the exact date and time in which this person would be testifying. We have several of the defendants with their attorneys stipulating to the use of video conferencing. And I really don't have any basis to find that the other factors, specifically as it relates to the participation via video conferencing, negatively impacting the dignity, solemnity, and decorum of the court using this technology. Nothing that I've seen so far would lead me to believe that that's going to be potentially an issue based on how the attorneys and the parties have been conducting themselves. I really think that in this particular case, it seems to be appropriate to permit it for exam purposes only, and that the factors weigh in favor of the people with this particular motion, obviously noting very clearly that the record's been preserved should the issue come up again as it relates to any other witness or any witness that may be expected to testify at a later date and time in this case. So I'm going to grant the motion, and then I'll wait for further instruction as to whether or not we need to file a motion as it pertains to Markin as well. But I'm assuming that this hearing may have some impact on their decision if they have not already signed off on a stipulation to allow video conferencing for this witness only. I'll probably need an order if you can prepare one as well.
Yeah, sure, Judge. I can get one to your staff tomorrow.
Okay. And then let's move on to the bond issue. So it's technically set for a hearing today.
All right, so that was the first part. Yeah, just some preliminary hearing issues. Now, let's see what entitled CEO, poor little thing in her mansion where she can't leave until trial and everything. Yeah, let's see what she did. I know you in the chat knows, but maybe for the people who are new to this or are just only listening, yeah, let's see what you did.
The issue of bond compliance was raised in August, and I think at that time, your client was placed on notice of what the allegation was, and there was an opportunity needed for you to further investigate. But it is my understanding that she has been made aware of the fact that because this is essentially a show cause date that we have scheduled for her to explain why she should not be held in contempt of court or to proceed to a hearing on the allegation. I'd like to first make sure that she's fully aware of the issue that's before the court as it relates to bond at this time.
Yes, Your Honor. And the record reflects.
Yeah, so it's not just bond violation, it's contempt of court. Usually, I'm used to other courts and judges where they just simply go by bond violation, but this is apparently even a contempt of court because it was not a mistake or she whoopsied. She did something really, really intentional.
Like that Mr. Kessel informed me of the allegations prior to. I don't think a written motion's been filed, but we would waive the written motion based on the information provided me by Mr. Kessel. It relates to a firearm that was sold in June of this year. There was a court order that required Miss Peterson to surrender all firearms in her possession, and that would include constructive or actual possession. We are prepared to admit that we violated that order. She's prepared to provide a factual basis for that. And
yeah, one of her conditions on bond, she cannot possess firearms, and she has to leave them to the court. And apparently, not only did she have a firearm, instead of handing it over, she sold it. Yeah, that's kind of a big deal. Not only didn't she notify the court that she had a gun, she sold it and thought, hey, I'm not going to tell the court either. But she was found out. They found out.
We recognized that we were entitled to a hearing, and by admitting that and submitting ourselves to the sanction of the court, that we'll be waiving that hearing, and the court will impose a sanction in that regard.
All right. Anything else that needs to be placed on the record?
No, not for the people, Judge. Thank you.
All right. Ms. Peterson, you've heard what your attorney has stated on the record.
Yes.
So the issue that's before the court today as it relates to bond is an allegation that you failed to comply with the bond condition that prohibited you from having in your possession or owning any weapons or firearms while the case was proceeding through the court system and you were on bond. Do you understand that?
Yes.
So it was brought to the court's attention based on information that was obtained from the Attorney General's office that at some point they became aware that there may be a violation as it relates to this specific condition. Do you understand that?
Yes.
If you want, we can proceed to a hearing. You have the right to require that the prosecutor present evidence to this court that you did in fact fail to comply with this condition. And you have the right to have this hearing because the potential outcome, if the court determines that you did not follow its order and you're in contempt of court, it could potentially be a jail sanction. Do you understand that?
Yes.
At this time, your attorney advises me that you've discussed this right to a hearing and it is your decision to waive your right to have a hearing on this issue. Is that correct?
Yes.
So at this point, could I leave it to you to question your client to establish a basis for a guilty plea on the violation?
Yes, sir. I believe she's prepared to make a statement to the court that would encompass that admission.
All right. So as it relates to the condition that you were not to have in your possession any weapons or firearms after release from Oakland County Jail, what is it that you did that makes you believe that you are guilty of violating this court order?
I failed to notify the court of a firearm that I constructively possessed with my husband. It was sold rather than surrendered to the court.
The weapon was...
So, her husband's gun. Now, I'm a bit... because she has the conditions on her. Does that mean that nobody in the household can have a gun? Now I understand. I mean, yeah, but her husband is not on trial. Why is his guns within? I understand why. I mean, she's under her bond condition, which means that in the household there can be no guns. But still, I mean, her husband's not on trial. But then again, they knew about the bond conditions. That's the rules. And if they surrender to the court, then he can always say, yeah, they can file motions and everything. And yeah, she should have told her lawyer. And yeah, as Kel says, doesn't matter. She can't be around firearms. He can store them. Yeah, but the court order is here, surrender them to the court. Mm. And Dave says, I hate constructive possession. Reminds me one day, or maybe later today, to tell you about a constructive possession case when I was prosecuted. Oh, please do. Please do. Yeah. I mean, he can always, I mean, if the husband has guns, store them at the gun club while your idiot wife is under bond conditions. Stuff like that. But yeah. But this also speaks to these people, she knew. Her lawyer knew. She should have told her husband. Mm. And Cal says he can get permission if they are registered to him for storage. Yeah. Then just file it with the court. Do not sell the fucking gun. Hello, Mr. Jimos.
Sold to someone else rather than being surrendered to the court.
Yes, Your Honor.
Okay. And how do you plead to this allegation that she failed to comply with the court order as it relates to the weapon surrender provision?
Guilty.
Okay. I will accept your guilty plea at this time. We have had some discussions about the court's inclination on how to handle this issue. Clearly, I am aware of the fact that she posted a significantly high cash fund, and that you have other conditions that have been in place since March, and then beyond that since your release from the jail that you've been asked to comply with. At this point, while you have had a number of months with no issues and strict adherence to home confinement, this type of allegation is very concerning to the court because it is, from the court's perspective, a very simple expectation that as it relates to possession or constructive possession of weapons or firearms, you were not to have any possession or control over weapons or firearms. And if it came to your attention that you had these or had the ability to constructively possess a weapon, you were to notify your attorney and to notify the court immediately so it could be surrendered. Do you understand that?
I understand.
So it causes me some concern because from my perspective, out of all of the things that have been placed upon you in terms of conditions, this one seems to me the easiest to comply with. I don't know if there's additional information that you want to place on the record, Mr. Gleason, or to just simply leave it at the statement that she's provided.
Your Honor, I'd put sentencing in the court's discretion.
Okay. But given the information that I have, the allegation and now your acknowledgement that you did not strictly adhere to that requirement, I think it warrants a sanction. I do believe that public safety can still be ensured by the conditions that are in place for bond and the cash bond that you posted. And this includes the monitoring with the tether and the home confinement. But this is a valid and very clear contempt of court issue where you did not comply with the order. And for that reason, a short but sure and swift jail sanction is going to be imposed today. You will spend the next 2 days in the Oakland County Jail, but no other conditions of your bond are going to be modified at this point.
Yeah, so for having constructive possession of a gun and then choose, instead of telling the court, they sold it. And for that, she gets 2 days in jail. And, well, it's a sanction. She didn't revoke the bond in its entirety. So 2 days. 2 days in jail. But I think what might be a little jail prep time. But I do believe that the actual punishment here is that this broad, Tamela Peterson, has been whining since she got out that her home confinement and the other things, oh, it's so hard on her. Oh, it's so hard on her. Please, judge, I need it easier. Yeah, that won't happen. That will not happen. I think she shot herself in the foot. So whatever things she try easier bond conditions, that is out the window, and I think that will be the actual punishment, because 2 days in jail, yeah, it won't be fun for her, but it's just 2 days. She will be home by weekend.
I think it should go without saying, but I'll say it anyway, because this case is taking its time here at this court, and I'm not expected to see you again until December. But if there are any additional issues regarding the compliance with each and every one of these bond conditions, you'll have to come back to see me immediately.
I don't think they can
And the
bring it
potential
up
for
at
you to
trial
maintain
that
the
she
bond
violated
that you have posted
bond
with the
conditions.
conditions that are in place.
I don't think they can bring it up, but if she is convicted, it can be a part of the sentencing. It might be.
It could be very unlikely. So that's the outcome for today's date as it relates to this violation. It is a 2-day sanction for contempt of court, and then we will continue on with the conditions. At some point, there was a motion asking for the court to modify some of those conditions, and I'm just not inclined to do that right now. I'm going to keep everything as is and hope that we can continue on to our next scheduled court date without issue as it relates to bond.
Understood, Your Honor.
So at this time, you'll just be taken into custody.
Okay.
Your Honor, before she is, if we could just switch out her high heels for a pair of lower heels for the jail, if that's appropriate.
They're right here.
You're okay.
Thank you. Thank you, Your Honor.
Yeah, and there she is. Off jail. Oh, Dave, you want to join? I'll send you a link.
You'll submit the order?
Yes, I'll make sure you guys have it by the end of tomorrow.
That sounds good.
Thank you, Judge.
Thank you.
Yeah, I'm not on StreamYard, I'm on Rumble Studio. But I did send Dave a link. Yeah, she even brought Flash to change into. Yeah, and off she fucks. Off she fucks. All right, so that was the contempt of court hearing, bond violation. Now, let's see here. No. Let's see here. Dun dun dun. Because we also have the what we started yesterday. We have the let's see, this because we started a few days ago with Tiffany Hosey, a former employee of this Oxford Clinic of Snake Oil Remedies. And so we listened to the state's direct examination. Now it is time for the 4 defendants to cross-examine Tiffany Hosey. And to my recollection, she was very, very nervous. It wasn't really clear if she actually warned everybody about these unsafe conditions or if it was inner dialogue. She wasn't sure about the dates. So I'm assuming that they will go quite hard on her, the defense attorneys. So that is Dave. I can't. Why? Dave.
Oh,
There you are. There you are. Hey.
Ooh, crazy over here on this side of things. Hey.
Hey.
Welcome myself. Hey, yeah, I know I want to talk about constructive possession because I don't like it. And there's a case here that I talked about a little while ago on one of my streams where 2 brothers roughed up a guy. The brother that I'm most concerned about, they're twins, so I'll call them Thing 1 and Thing 2, right? So Thing 1 has a little baton and roughs the guy up. Thing 2 has a firearm. And Thing 1 has a prior felony. He can't be in possession of a firearm. He claims he has no knowledge of the firearm, but the state keeps pushing the issue because the brother had it in Thing 1's car, and therefore that was constructive possession, which is insane to me. So the Michigan courts have clarified that constructive possession requires proximity to the firearm along with the initia of control. So that's like the idea of control. For example, a firearm being located in a place where the defendant knows that it is with reasonable access can satisfy this. And so this case that made me quit the prosecutor's office, it wasn't a firearm, but I want to give you the facts of this case. I was ordered to prosecute this young lady. She was 16. She is in the front passenger seat of her boyfriend's car. Her boyfriend is, I think, 18 with a fake ID. He goes to he picks her up from her house in his car. He drives to a store. He goes in. She stays in the car. He goes in and buys alcohol with his money. He comes out, puts it in the back seat. She never touches it. And then he continues driving down the road. He's later, I think, pulled over, and he's charged with minor in possession. She is also charged with minor in possession, and I'm assigned to prosecute the case. And I'm looking at this thing, how is this possession? But the law is, because she was in theory able to exercise control over it, constructive possession, even though she didn't buy it, never set a finger on it, she is in constructive possession and therefore a minor in possession of alcohol. That's how flimsy this is. So they didn't really get into the facts of this firearm, where it was, how the husband sold it. You know, it wasn't even the husband's.
Yeah.
You know, but you know, you guys in chat and you were talking about, you know, store it at the hunt club, store it in something else. It doesn't matter if it's stored if the court finds that she had the possibility of accessing it, then it would be constructive possession. And I don't like that because he didn't do anything. The husband didn't do anything, and
No.
his rights are being stripped, right?
Yeah.
But
Yeah.
that's it. But that case, it was just so. I'm like, really, we're pushing this issue. We're making up this idea that, well, in theory, anyone could be in possession of anything as long as they know where it's at under this theory, right?
Mm.
So it's. I just don't like the way Michigan courts have come down on it, and I just wanted to explain that. That's all.
Okay. Yeah.
So it might be something completely like she might not even have known it existed until her husband said, "Hey, I sold this gun," rather than giving it to the state or something like that, and now she knows about it, so now she's violated. Anyway, so I just thought I'd.
Yeah, but also, I mean, her attorney should have explained this with everybody in the household. Yeah,
Well-
all your guns.
Well,
all of them.
you do. You explain these things to clients, right? But you don't explain every possible scenario.
Yeah.
Right? You explain in broad terms, you try to get details, you try to give examples. If you, sir, own a gun, you can't have it in the house either. You need to get rid of it and things like that. But you don't go over every possible detail. There's always the clients are always going to do something that you weren't thinking about.
Yeah.
You're like, oh, I'm going to use that for my next example, right? So I don't want to go. I'm not a fan of this case. I'm not a fan of these people. But I just want to give her a little bit of the benefit of the doubt on this one.
Yeah. Yeah. I mean, I think it's I think it's stupid because it's not her gun.
Right. It doesn't
His
sound
gun.
Yeah.
He is not charged. He still have rights. But apparently not in Michigan.
Yeah, and it's interesting too, as who just brought it up KEL. I don't know KEL. Hello. Talking about in Arizona with it being locked up made me think about the Michigan law now. If you have a firearm and a minor child in the house, you have to have it locked up. But is the child still in constructive possession of it if they somehow, unbeknownst to you, know how to access it? It brings up a lot of weird gray areas that I don't like. They're going to get you if they want to, that sort of thing.
Yeah.
So that's all. But that was interesting. I saw the bond violation on the docket and I was like, ooh, what's this about? Better check Texas law around my stepson. I feel like Texas might be a little more lenient than Michigan when it comes to firearms. Just a thought.
Yeah. Generally, they are a bit more liberal regarding guns.
Yeah.
But you never know. There might be a constructive possession in Texas as well.
Yeah, I just know it's really just if they want to hit you with constructive possession, they will in Michigan. They can do it. The law backs them. So that's all. But alrighty. Well, I'm gonna go bake a pie. I just wanted to explain that.
Okay. All right. And we will continue to listen to the cross-examination of the witness from the other day.
Yeah.
Tiffany Hosey, the former employee, and she was a bit flimsy in her answering. I would assume, because these are some good lawyers on the defense side, that their cross-examination might be quite ruthless.
Did you start the cross? Because I don't think I heard
No, you just came on as I was about to press play.
Okay. Well, I'll jump out. I'm going to watch it in chat. But their objections during the direct examination was great. And I also want to say one thing about that woman that was testifying. I don't trust her. Something's up.
Yeah.
The way she answered questions, the way she answered certain questions, because I can get if you're nervous and you have sort of a pattern because of the nervousness, but there was a distinct set of questions about who you informed.
Yeah.
That she deliberately paused on and looked like she didn't. It almost looked like she was formulating the will to perhaps lie, maybe. Because it just didn't seem consistent with the rest of her. I don't want to go into the behavioral things, but that plays in the eyes of the jury. That's why I'm not a behavioral scientist. It's junk science, but that's that's something that a juror might pick up on.
Yeah, because she was employed there between 2021 and 2024. And I do know from prior proceedings that the tampering with the maintenance log started in 2021.
No. Interesting.
And now it's two different. She was employed at the other location.
Right. The one that's actually like down the road from me.
Yeah.
Apparently. I didn't know it existed, but yeah.
Which also means, I mean, technically, if she was involved in some way, or at least knew about the tampering of the maintenance log, she might have a minor infraction that the state could put on her.
Well, they should definitely, the defense on this cross should definitely be questioning her about that, because it does go to bias. Absolutely. Like imagine if hypothetical people, I'm not saying this is true, but imagine she is involved with manipulating the logs and things like that. She's been doing illegal activity, and all of this happens, and the police go to her, and she's like, "Tell me whatever you want me to say. I'm here to play ball." Oh, I happily. Well, did you notice anything illegal? Yes, I noticed this, and this. Well, did you report it to anybody? And whether she did or not, she's thinking, well, if I reported it to somebody, then it gets me off the hook. I'd be happy to say that. I'm not saying the prosecutor is leading her or coaching her, but there's definitely the possibility of her being biased and involved and potentially lying to cover her own ass. And they need to dive into that somehow.
Yeah. So this will be, because I haven't listened to a word of the cross-examinations.
Okay.
So it will be interesting.
I'm going to listen. I'll be in chat.
Okay.
All right. Take care, all.
Yeah. See you.
See you.
Good morning. Good morning. How are you?
Rough.
Okay. I'm the attorney for Mr. Mosteller. I have quite a few questions for you. I'm obviously not a woman of science, so if I use a phrase or a word that you think I'm not using appropriately, will you please correct me? Do not be bashful in that sense, okay? Okay, because I want to try and make as clear a record as we can, okay?
Okay.
I need to get me something to drink. I will be right back. And I'm back.
Okay, so you started working at the Oxford Center in September of 2020, correct?
Correct.
Okay, and that was part-time?
4 days a week.
Okay, and your employment lasted through roughly April of 2024?
Yes.
Okay, and sort of at the end of your testimony, you were talking about the situation under which you left the Oxford Center in April of 2024, correct?
Correct.
Okay, and you had expressed some concern or a desire to not work in the hyperbaric suite anymore, correct?
I was uncomfortable in the hyperbaric suite.
Okay, and it was at that time that, according to you, Ms. Peterson told you that she could no longer fund your research.
If I wasn't able to supplement my time in the hyperbaric suite, correct?
Okay, and your discomfort in working in the hyperbaric suite stemmed from the safety concerns that you allegedly had, yes?
Yes.
Okay. Did you work in the hyperbaric suite in 2020 when you were there?
Yes.
Did you work in 2021?
Yes.
Did you work in 2022?
Yes.
Did you work in 2023?
I did.
And you worked in 2024?
Yes.
So for nearly 4 years, you continued your employment at the Oxford Center despite these alleged safety concerns that you had, correct?
Correct.
Okay. And you subjected patients to treatments that you allegedly had safety concerns about, correct?
That's true.
Okay. And the only time that you left the Oxford Center is when they wouldn't bankroll your research anymore. Isn't that correct?
I'm sorry, what are you saying?
Well, let me ask you. You stay there for nearly 48 months, correct? You're like 3 months shy, if my math is correct, of 48 months, correct? And you allegedly had these safety concerns those entire 45 months. Is that fair?
That is fair.
Okay. But you were willing to continue to treat patients in a way that you allegedly thought was unsafe as long as you were getting money to conduct your research?
I think you're misunderstanding. The
No.
research wasn't like a bankroll for me. I was paid at an hourly rate. It was Tammy's research that we were doing.
Okay. Were you employed by the Oxford Center?
Yeah.
Were they paying you, whether it was by the hour or with a salary?
Yes.
Okay. And the majority of your obligation was research based, correct?
Yes.
And that's what you wanted to do. I mean, you didn't want to be a tech. You wanted to be working in research. That's really where your interest is, isn't it?
That's not true.
You prefer to work as a tech?
I do prefer hyperbaric medicine technician, yeah.
Okay. So you were only working 4 days a week when you started at the Oxford Center.
Mhm.
And how is that a yes?
Yeah.
Okay, I know it's hard to remember. How did you divide your time, let's say in 2021, between working as a tech and working on research?
If I had to put a number on it, it was 80% research, 20% tech.
Did you ever communicate to anybody that you preferred to work more as a tech?
No.
Okay, what about in 2022? What do you think your division was then between tech and research?
It was probably roughly the same.
Okay. Did you ever communicate in 2022 that you preferred to work as a tech than in research?
I think you misunderstand what I'm saying.
Can you please answer the question that is before you, ma'am? In 2023, did you ever convey your desires to work more as a tech than you did in research?
No.
What about in 2024?
No.
Okay, so when you come to work for the center, actually, no, I'm going to go back for a second. Given the fact that you were employed at this center for roughly 45 months, during which you allegedly had all these safety concerns, did you report it to any outside agency?
Officially report? No.
Okay, so you only took your concerns in-house. Is that fair?
That's true.
Okay. Are you worried sitting here today that you face any criminal liability in this case, given your silence for 45 months?
Yes.
Okay. Does that play a role in your coming and being a witness for the prosecution?
No.
Has there been any conversation between you and the prosecution that you may not face criminal charges if you cooperate with the prosecution?
No.
But that is a concern that you have in the back of your head.
Yes.
Here we go. Yep.
Prior to the Oxford Center, you worked as a tech in how many other locations?
One.
And where was that?
Detroit Receiving Hospital.
Okay. If you know, because I don't know if you know, do all locations treat all ages of patients?
Not all locations treat all ages. No.
Okay. In fact, some hospitals don't treat pediatrics. Isn't that correct?
That's true.
Okay. Are there other centers, if you know, that also don't treat children?
Yes.
Okay. When you worked at Detroit Receiving, did they treat children?
Yes.
Okay. Did they treat children with behavioral problems?
They weren't treating for that condition, but patients that had behavioral problems with other conditions were treated.
Okay.
Does that make sense?
Yes. And when let's say, did you ever see patients in the hospital, pediatric patients with ADHD?
Not as their primary reason for being treated, but along with another condition, yeah.
And what about autistic children?
I have not treated other autistic children outside of the Oxford Center.
So we'll come back to that. So you start in September of 2020, and you've already established you already knew Mr. Mosteller and you knew Ms. Peterson, correct?
Correct.
Your time at the Oxford Center, and I'm referencing Brighton because that's where you worked, did you cross paths with a gentleman by the name of Andrew, is it McMullen?
Yes.
Yes. How much time did you overlap with Andrew?
I would guess roughly a year.
Okay. And you described Mr. Markin as Tammy's right-hand man. Was that correct?
Yes.
Would you give that same description to Mr. Mosteller?
No.
If you had to rank authority, who would be at the top?
Tammy.
And second to Tammy, Ms. Peterson?
Like just overall,
If you were ranking authority, who had the most authority over the Oxford Center?
Tammy and then Gary.
And then?
Jeff.
Okay. I want to talk about this concern about the lack of patient grounding, okay? I'm going to say something. I want you to tell me if I'm accurate, okay? Grounding.
This is a good point from Dave. By the way, we're totally glossing over the fact that any respectable therapist would say that this child was too young to be diagnosed with any mental health issues, let alone ADHD. Yeah, he was 5 years old, and they started the treatment there a year earlier. Now, I do know that kids can be diagnosed as early as 4 years old, but it's rare. Very rare. That's a good point. Thank you, Dave. But this is a facility that makes money out of worried parents?
Is the conducting of electricity or static through the chamber and outside into a pole that goes into the ground. Is that pretty accurate?
Yeah.
Okay, so it's essentially wanting to take any electricity that's in the chamber and safely running it into the ground and out the building. Is that okay?
Yeah.
Okay. So now I'd like for you to explain to me, well, let me ask you this. Isn't it true that this strap, the wrist strap that we've talked about, is not the only way in which a chamber is grounded?
True.
Okay, tell me all the ways in which a chamber is grounded.
The physical chamber is also grounded to the ground.
Okay, so when you say the chamber is physically grounded, it's several different parts of the chamber that are grounded, correct?
There's one wire that comes out of the chamber into the wall, into the ground.
Okay, is the mattress of the chamber grounded?
Yes.
Okay.
Yes.
To the chamber. Okay, and if I use the phrase gurney, is that so what the patient lays on? So the patient lays on a mattress, the mattress is on a gurney. Is that word okay for that piece of equipment? Okay, that gurney is grounded, correct?
Yes.
Okay, that gurney slides into the chamber and there's like 2 metal rods that the gurney lays on. Is that fair?
Yeah.
Okay, are those metal rods grounded?
Yes.
Okay, so are there any other parts that are grounded that I have not specified?
The whole thing is grounded. Once the chamber has a wire that goes out the back into the ground, then everything connected to that should be grounded.
Okay, so everything connected to that. So if I'm a patient laying on a mattress that is grounded, laying on a gurney that's grounded, that is placed on metal poles or rods that is grounded, am I not grounded?
You would have to talk to the chamber manufacturer on that one.
Well,
They recommend having a patient strap.
okay. To be fair, Ms. Hosey, I mean, you're testifying here about safety concerns that you had, criticizing a test that Mr. Mosteller did, and so I'm asking you, if I'm a patient laying on a grounded mattress that is placed on a grounded gurney, that is placed on grounded metal rods in a chamber that in its entirety is grounded, am I not grounded?
I'm also not an engineer, so I cannot answer that. I can tell you what the chamber manufacturer says and what the fire code.
So can you say for certain, sitting here today, that a patient is not grounded if they are in a chamber, on a grounded mattress, on a grounded gurney, on grounded metal rods, in a grounded chamber? Can you say with certainty that the patient is not grounded?
I would say that unless they had a grounding strap on, they were not grounded to the chamber.
Even though they're laying on 3 layers of grounding? Is that your answer?
I'm saying the patient needs a grounding strap to be in a monofilament.
Ms. Hosey, I'm asking you to please answer the question that is before you.
Judge, I have to object. She's trying to answer the question just because she's not getting the answer defense counsel wants. It doesn't mean she gets to interrupt with another question.
No, she wants, sorry, please, go ahead.
You can speak. She has to be allowed to finish her question, answer the question before she moves on to another question.
Respectfully, Your Honor, I've asked her the same question now 3 times that she hasn't answered.
And she has answered.
But, okay, she's also been very clear in the fact that she's not an engineer and she would not be able to provide the information that you're seeking specifically.
Okay,
So I
so
think she's answered the question at this point.
if I may just clarify one time, Your Honor.
To ask another question?
Yes, regarding the subject.
Yes.
If you're not an engineer, which you just said that you're not, how can you say with certainty that the patient isn't grounded if the patient is laying on a grounded mattress, on a grounded gurney, on grounded metal rods, in a grounded chamber?
The patient does not have a grounding strap on. They're not grounded to the chamber.
And that's based on what?
Based on the National Fire Code and the chamber manufacturer recommendations and my education.
So are you saying that these manuals that you're citing explicitly say that if a strap is not on a patient, they are not grounded? Is that what you're saying?
I'm saying the manufacturer's recommendation and the National Fire Code require patients to wear a grounding strap during treatment.
Okay. So I'll ask my question again because your answer is not responsive. Are you saying
I'm going to object. And she has answered the question to the best of her ability. She's answered it now 3 times.
no?
The question has been asked and answered. Please move on.
Do you believe that there was a strangulation risk with the cord of the wrist strap?
No.
Why not?
I've never heard of a case of a child strangulating himself or anyone strangling himself with a wrist strap.
Okay. And that proves to you that it could never happen? Does someone have to die in order for it to be proven to you that it could happen? I mean, it's a cord that's in the chamber with the child, correct?
Yes.
Okay. And just in case people are not familiar, because I was not particularly familiar, especially with a child, there is a lot of room for movement in this chamber, correct?
Correct.
Okay, there's room for the children to sit up, lay down, raise their hands, depending on how large they are. Is that correct?
Yes.
Okay. And at Oxford Center, they were treating children with some pretty severe behavioral issues, correct?
Correct.
Okay. Do you think it's out of the realm of possibility that one of these children with behavioral issues could play with that strap and place it around his neck?
No.
It's not out of the realm of
It could happen.
Okay. So now let's talk about that possibility, okay? The treatments at the Oxford Center, it takes, when a patient starts a dive, and this is whether it's an adult or a child, it takes 10 minutes to fully pressurize the chamber, correct?
It could go faster, but generally, yes, 10 minutes is standard.
Well, I'm asking you what they used at the Oxford Center, given your experience there. It took 10 minutes to reach full pressurization, correct?
I wouldn't put an exact number. Depending on the size of the patient and the rate that you pressurize the chamber, that 10 minutes could vary pretty wildly. You can pressurize the chamber within 2 or 3 minutes, or you could take as long as 20 minutes.
Okay. In the time that you worked at the Oxford Center, did you ever fully pressurize a chamber in 2 minutes?
Not with the patient inside, no.
Okay. Did you ever fully pressurize a chamber in 20 minutes?
Yes.
It took you 20 minutes to pressurize?
If someone's having trouble clearing their ears, you would take it very slowly, yes.
Okay. What was the standard rate at Oxford Center for pressurizing the chamber?
2 psi per minute.
Which would take 10 minutes, correct?
Sure.
Okay. And then the patient is in the chamber receiving treatment at this full pressure for 60 minutes, correct?
Yes.
Okay. And then you have to depressurize, right, to end the dive.
Yes.
Okay. And that also takes 10 minutes, correct?
Yes.
It's happening at the same rate as the pressurization, but in reverse, correct?
Correct.
Okay. Now, if there's an emergency in that chamber, and you kind of touched on this, you can depressurize much faster, correct?
Yes.
Okay. What is the fastest you can depressurize a chamber? It's 2 minutes, correct?
From which depth?
If I'm at 100% oxygen, I'm in the middle of my dive, okay, and I'm a child, and I wrap that strap around my neck, okay, and I'm at 100%, what is the fastest you can bring me back up?
Depends on how deep the pressure in the chamber was. So the deeper the pressure, the longer it would take.
What's the fastest that you could bring me back and open the chamber door?
You would have to account for the size of the person inside the chamber and how deep that they are, but minutes, 2 to 3 minutes.
Okay, so the fastest you could access and open that chamber door is 2 to 3 minutes, correct?
Correct.
Okay, which means if a child had placed a strap around their neck, the fastest an adult could get in there and help that child is 2 to 3 minutes, correct?
Correct.
Okay, now there's a tech outside the chamber, and that tech can communicate, right? The person in the chamber can hear the person outside the chamber, correct?
Through a telephone, yes.
Okay, but if the child is someone with autism or has behavioral issues, that necessarily isn't going to work. Would you agree?
Yes.
Okay, now let's say you were going to pressurize the chamber at this 2 to 3 minute rate, okay? That brings with it inherent health risks, doesn't it?
Yes.
Okay, tell me some of those.
If you're ascending, like depressurizing the chamber in 2 or 3 minutes, you are expanding all the air spaces in their body, including their lungs. So if they are not breathing, you can overexpand their lungs.
Are there any other health concerns? Any other health dangers? Could you cause permanent damage to their ears?
Not on depressurization, no.
Not to the heart?
No.
That's your opinion?
Yes.
Okay. So we've now established that it's certainly possible that a child, especially one with behavioral problems, could get that strap. The strap is long, correct? I guess let me put it to you this way. The strap is long enough that it could reach around a child's head. You would agree?
Yes.
Okay. And that if that were to happen, the fastest an adult could access that child would be 2 to 3 minutes, correct?
Correct.
And doing that would put the child's health potentially severely at risk.
If they strangulate themselves, yes, they're at risk.
Or just the fact that you're pressure.
This attorney is on fire. Do I agree with all the speculations here? No, because I do believe her series of questions regarding the strap around the arm and the risk of putting it around a child's neck if a child has behavior issues, doesn't that say you should not treat kids? The point I believe the defense here is trying to make is they are grounded because they are in there and everything about it is grounded. There's no need for the wrist strap. My automatic response to that would be, well, then they shouldn't treat young kids with behavioral issues at all, if that is the risk. So I'm not entirely sure. I don't think that this will. Now, this is a hearing. It's in front of the judge. They will go out guns blazing. But if there was a juror there, as the state, I would go, so you shouldn't treat kids at all. Yeah, as Nicola Cox says, they didn't do any risk assessment to this. No, because Tamela Peterson was all about the money. Hey, parents, I know this isn't covered by Medicaid. I know this isn't, your insurance company won't pay for it, but I promise it will help your children. And desperate parents will pay a lot of money to get their kids better. And she was preying on that.
Pressurizing the chamber so quickly.
Depressurizing the chamber.
Thank you very much. That's what I said. Please correct me. And when you're depressurizing so quickly, there's additional health concerns aside from potentially a strap around a child's neck, correct?
Correct.
Okay. Okay, let's talk now about the phrase test experiment were kind of interchanged. Okay, so let's talk about that. The grounding of a chamber and of different parts of a chamber is measured with a multimeter, correct?
Yes.
Okay, and the safe reading on the multimeter has to be below 10 ohms, correct?
10 ohms.
Are you not familiar with how to check the grounding of a chamber?
I do. It's usually 0 or 1.
0 or 1?
Mm-hmm.
Okay, and what is that based on?
Can you rephrase your question?
The question is, you just gave testimony. What's your testimony based on?
National Fire Code and the UHMS guidelines and chamber manufacturer recommendations.
Your Honor, may I approach? This is from the Seacrest manual. Well, let me ask you this. Are you familiar with the Seacrest manual?
I'm aware there is one. I don't know every word in it.
You've given a lot of testimony today asserting that safety measures were not followed because of what's contained in the Seacrest manual. Have you or have you not read the Seacrest manual?
I have read especially the section on patient grounding.
Okay, so would you agree that the manual gives instructions on how to test grounding in a variety of ways?
Yes.
Okay, so Your Honor, may I approach to ask her if she's familiar with part of the manual?
Yes, can you please show the prosecution what you're going to put the break for?
Is this familiar to you? Have you ever reviewed that portion of the manual?
Yes.
Okay, and what does it say here is an acceptable reading?
Between 0 and 10.
10 ohms?
Could you just ask the question again? I'm not sure she can hear you.
Oh, I apologize. 10 ohms?
Yes.
Okay. So let's talk about some of the testing that Mr. Mosteller did. Your Honor, I have a series of exhibits that are already marked. A set has been provided to the prosecution. Mr. Kessel had an opportunity to review them. Full disclosure, Your Honor, the last two somehow didn't make it into the duplicate stack, so he does not have O and P. I will remedy that, but he did review them this morning.
That's correct.
Okay.
Uh,
Or have you like to approach with those? Is that what you're doing?
I would. It's Defense Exhibit C through P as in Paul.
Okay. And you had a chance to review them?
I have it.
And I'll let you approach with those first.
Thank you.
Your Honor, is it okay if I kind of stay up here to review the exhibits with her? And I'll ask the boss. Is it okay?
No? Okay. Can you try and see if it works? Okay. All right. This is Defendant's Exhibit C. Can you tell me what's in that photograph?
It looks like a multimeter and ohmmeter.
Okay. And is that testing the grounding of the chamber?
I can see one end is put into the chamber jack. It looks like the other end is just touching a patient or a person.
Does that give an indication if the person is grounded, depending on the reading of the ohms on the multimeter?
So it's 4.8.
Okay. Below 10?
Yes.
Have you seen this photo before?
No,
Is this not duplicative of the video that you saw of the test he was running?
I can't tell.
Okay. Let me ask you something. Is there a person in the chamber in that photograph?
Yes.
Okay.
Is there a sheet on the mattress in that photograph?
Yes.
Do you remember earlier when you criticized Mr. Mosteller's test, saying that there was no sheet on the mattress?
Yes. What I recall is seeing a video of Sam outside the chamber on the gurney with no sheet.
Okay. In this photo, is that Sam?
It's hard to tell from that angle.
Is that a human being?
It is.
Okay. On a sheet, on a mattress, inside the chamber, correct?
Yes.
Okay. Let's go to Defense Exhibit D. Is that a similar photo?
Yes.
Okay. What's the reading on the multimeter?
4.63.
Below 10?
Yes.
And this human being that you're not sure if it's Sam is on the stretcher, on the gurney,
Yes.
on a sheet,
Yes.
inside the chamber?
True.
Let's go to Defense Exhibit E.
Can I just ask for just one point of clarification? Yes. Are these proposed exhibits? Are these exhibits that are stipulated to?
They're only proposed at this point.
Okay, I just want to.
Not these.
Oh, you didn't stipulate them? Oh, I'm sorry, I misheard that.
I haven't heard sufficient foundation for their admission yet. I'm waiting to hear that before I make a decision about whether or not I
Okay,
can.
so I
I thought Mr. Kessel had stipulated, but I'm.
It's good that I asked.
That's not to the admission of them.
Okay.
Yeah.
That's all.
Okay, so at this point, let's just make sure the record correctly reflects that there's a proposed exhibits at this time. We can continue to ask questions in order to determine if there's an appropriate foundation, and we'll address it in a moment.
Okay, thank you. So we're on Proposed Exhibit E. Okay. Is that a human being
Yes.
inside the chamber?
Yes. Unpressurized with the door open.
Okay. You know, it's funny you bring that up. I'll step back for a second. Tell me what manual or what safety booklet instructs a technician to check the grounding of a chamber while it's pressurized?
Generally check the grounding prior to pressurization.
Okay, so earlier, when on direct examination, when you were criticizing Mr. Mosteller's test, saying it wasn't valid because the chamber wasn't pressurized, there's no manual that instructs a tech to check while the chamber is pressurized, correct?
True.
Okay. Okay, so now let's go back to proposed defense exhibit E. A human being in the chamber on the mattress with a sheet, correct?
Yes.
And is the ohm reading below 10?
Yes.
Okay. Is that true of proposed defendants exhibit F?
Yes.
Okay. Now, proposed defendants exhibit G is checking the grounding of the wrist strap, correct?
It's hard to see where that wrist strap connects to.
All right, let me give you a different one. Defendants exhibit H.
I see the wrist strap, but I can't see where it's connecting.
Okay.
I can assume it's into the patient ground section, but I can't see it.
Proposed defendants exhibit I. That's checking the grounding on the underside of the gurney, correct?
Yes.
And the reading on the multimeter?
0.
Okay. Defendants proposed exhibit J. That's checking the grounding on another part of the gurney, correct?
Yes.
Okay. And the reading on the multimeter is 0?
It is.
Okay. Defendants proposed exhibit K. Is that the same thing? But just testing another third area of the gurney?
Yes.
And the reading on the multimeter is 0?
It is.
Proposed defendants exhibit L. That is testing the grounding on a metal bar on which the gurney would lay, correct?
Yes.
And the reading on the multimeter?
Is 0.
Defendants proposed exhibit M. That's checking the grounding of what?
It's connected. It's touching a metal bolt on the chamber hull.
And the reading on the multimeter?
Is 0.
Proposed defendants exhibit O. What's that checking?
I can't see where he's putting the other end of that wire.
Is it on the top of the gurney?
Is it in his hand?
Okay, are you unsure?
I can't see where that end
Okay.
is touching.
Defendants proposed exhibit P, as in Paul. That's checking the grounding of what I referred to earlier as the kind of the metal rod that the gurney lays on, correct?
Correct.
And what's the reading on the multimeter for that?
It says 0.
Okay, so in all of these pictures, and is this similar to what is displayed in the photos that we just discussed? Are those similar to the test video that you saw Mr. Mosteller conduct with the chamber?
What I saw in the video was Sam laying on the gurney outside of the chamber without a sheet, but also that multimeter proving to them that that it was safe without the grounding strap.
Okay, would you agree with me that in defendants exhibit P, M, L, K, J, I, F, E, D, and C, those are all the ones that you could clearly see what was happening. The ones,
She's going to ask her for a conclusion about what these pictures represent. And before we get there, I'd like an opportunity to go idea on her knowledge of these photographs and what they represent. When we're there yet. Okay.
I mean, if you want to idea, that's fine.
Thanks. Those photographs, do you know when they were taken?
No,
Do you know who took them?
no,
Do you know where they were taken?
no,
You didn't take them?
no,
You don't know who did?
no, ma'am.
This is from Diane saying, Nick, I just asked my husband, who was a lineman, about the grounding issue. He said, the potential for static should require the grounding of the human along with the chamber and the gurney and the rods. And I completely agree. Everything in that. If you are even supposed to use it in this type of situation, yeah, everything should be grounded. So the defense here is claiming, treating kids and kids, yeah, you know how kids are. They could, that arm strap, they could twist it around their head. It's a good tactic against her in this situation. Problem here is, it tells me, don't put fucking kids in the chamber. Especially not kids with behavioral issues. But that's the selling point of this entire operation, is to treat kids with behavioral issues. Which makes this... kids wiggle, yeah, as Castro says, kids wiggle. Static can happen.
Do you know why they were taken?
No,
You indicated on cross-examination that there's this multimeter and it's giving some readings. Is that right?
Yeah.
Do you know why it's giving those readings?
showing resistance or no resistance between the 2 points that's connecting to.
If that is accurate, if the photographs accurately depict what's going on,
Right.
do you know whether or not those photographs accurately depict that?
I don't.
Do you know, showing you Exhibit C, this yellow device, what is this?
A multimeter.
Does a multimeter measure things other than just ohms?
Yes.
So you don't know what this is measuring, is that right?
No, I can't tell.
Thank you, I have nothing further.
Okay, that was first cross-examination. Who's next?
What other unit of measurement, I don't even know if that's the correct phrase to use, does a multimeter measure in?
It has a full dial of different types of measurements, so I have to look at each multimeter to know. I don't know.
Okay, and you're saying that looking at this, you don't know if it's in ohms?
I can't tell.
What other measurement would you use to measure a chamber?
But ohms is what I would normally use.
Okay, I mean, would any other type of measurement even be relevant?
I don't know.
Okay, do you know if anyone else conducted any type of testing like this on the chambers other than Mr. Mosteller?
The manufacturer.
Okay, you think this is potentially pictures taken by the manufacturer?
Objection, that's a mischaracterization of what you said.
It was a question.
Was whether or not anybody else would take pictures, not if these pictures represent that.
So you're saying you don't know who took the photographs?
I don't know.
Do these photographs accurately depict how the grounding of a chamber would be measured with a multimeter?
Usually when you check the chamber ground, you would connect that multimeter to the chamber, to those holes. So yes.
Okay, so this is an accurate representation of how you would check the grounding of a chamber using a multimeter.
Having a hard time
I'm not
answering.
familiar with that, what they're using right there. When we check the multi-place chamber, we're checking 2 separate points. In a monoplace chamber, it's a little different. So prior to each hyperbaric treatment in the monoplace chamber, we're checking the patient ground, and the chamber ground is generally a once a week check. and we're looking at the other side of the chamber. So the other end of the chamber, there is a ground coming out of the chamber. So you check the ohms meter on that. So I don't see it.
Okay, so is it your opinion that touching the multimeter to various parts of the chamber does not indicate that it's grounded?
You could do it that way, yes.
Okay, so when you look at this photograph and the reading on the multimeter, what is your takeaway from this photo that these various parts of the chamber are grounded?
Yes.
And again, you can't tell if that's Sam in the photo?
Not definitively. I know Sam, it's similar to Sam, but I can't tell. It's like I have the top of his face and the top
Sure.
of his nose. I can't look at his eyes or his full profile.
Your Honor, I think the foundation is sufficient for admission of the photographs for which she could identify exactly where the multimeter was plugged into and the locations of the chamber to which the multimeter was connected. I mean, she's indicated that what she takes away from these photographs is that the chamber is appropriately grounded, that the readings on the multimeter are appropriate given what the standards are.
I disagree. And when it's appropriate for me to make that response, I will. I just didn't know if the defense counsel was going to share. Yeah, I don't think that she can say, because she has to be able to say with certainty that the photographs actually depict what they purport to depict. And she's already said she doesn't know when, she doesn't know where, she doesn't know what. She said a multimeter can measure other things. She's not sure if that's what it's actually doing. And so without being there to be able to see this experiment and how this thing is working, I don't think she can fairly say that these photographs.
Yeah. What this, I believe, is why the state didn't have her as an expert witness, because these are conditions for an expert witness that the defense is trying to get all of these admitted. So it's a smart move by the state to not have her there as an expert as well as a fact witness. They need more. They need more.
Or what defense counsel reports them to be.
Yeah, rise to just disagree with that. The foundation is a fair and accurate conviction of what she's talking about, and it goes to weight, not admissibility, Your Honor.
Yeah.
And as on behalf of my client, Gary Markin, I would ask that you admit those because you can give whatever weight you want to give them.
Well, I want to be very clear about the foundation that I think has been laid. It appeared when they were initially presented to the witness for review as proposed exhibits that the connection was thought to be made that they were somehow related to the video that she's already testified to. And there was nothing in the testimony that she's provided that would indicate that she is able to in any way, shape, or form testify under oath that that's what those pictures are taken from. She's also clearly indicated she's not the person that took the pictures. And I haven't heard any testimony that would even lead me to believe that the machine that's in the pictures is one that was located at the facility she worked at, the Troy facility. So it was a little bit of a winding path here, but ultimately it doesn't appear that Ms. Sharon is seeking to admit them as some representation of the video that she testified to. And without anything that I've stated on the record that I think would be necessary to lay the foundation, I just simply don't think it would be laid based on the testimony that I've heard today.
I'll leave it to your discretion.
Sure.
Your Honor, may I ask a couple additional questions?
You can, and this is not to say that they can't be reintroduced with a different witness. I just don't think that this witness has been able to lay the foundation for the court to admit them.
Sure. Ms. Hosey, if you need me to bring these back up to you, then that's fine. But do you recognize which center these photos would have been taken in?
No.
Does it resemble either Brighton or Troy?
And it looks like a monoplace chamber, so it could be either one.
Okay. Do you have any doubt that it was taken in either Brighton or Troy?
I don't know where they were taken.
Okay. Your Honor, I'll move on then. I'll admit them to a different witness.
Sure.
Okay, so let me ask you a question. Before you criticized the test run by Mr. Mosteller because the chamber wasn't pressurized, and we've now established that there is no literature, no manual, nothing that tells you to check the grounding of a chamber when it is pressurized, correct?
What's your question?
On direct exam, okay, you testified that you thought the tests run by Mr. Mosteller were not valid, correct?
Correct.
Okay, one of your criticisms was that the testing of the chamber was not, the grounding check of the chamber was not done while it was pressurized, correct?
I wouldn't call it a criticism, it was just a note. But no matter what test he did, it doesn't supersede what the National Fire Code and the chamber manufacturer recommends, which is why I was sort of standing on those.
So again, I'm going to ask you, is there any instruction manual, booklet, safety manual, anything that says the grounding of the chamber should be checked when it's pressurized?
No.
Okay, so if you check a chamber and it is showing that it is grounded when it is not pressurized, that is a valid reading, correct?
Correct.
Okay. Your other criticism was that the grounding wasn't checked when there was a patient inside the chamber. What manual, literature, safety manual tells you that the grounding of a chamber has to be checked with a patient laying inside the chamber?
If you were checking the patient ground, the patient has to be on the gurney with a wrist strap on.
Okay. Again, I'm asking checking the grounding of the chamber, and the various multiple parts of the chamber that you have now acknowledged are all grounded. If that is what you are checking, what manual or safety literature tells you that a patient has to be in the chamber to get a valid reading if the chamber is grounded?
You have to be on the gurney with the wrist strap on to check the patient ground.
I have now asked the question, what will be my third time? I am talking about checking the grounding of the chamber. Okay? So if you are checking the grounding of a chamber, what tells you that a patient has to be inside of it?
The patient does not have to be inside it.
Thank you. In the video that you referenced, that you saw, okay, Mr. Mosteller, did he check the grounding on various parts of the chamber?
I don't know.
You don't remember what you saw in this
I
video?
remember seeing Sam laying on the stretcher with no sheet and them using the multimeter to check the ground. I don't remember the numbers were on there. I don't remember the exact specifics because in my mind, when I'm looking at that test, I know that it does not matter what his result was. It doesn't meet the standards.
Okay, so do you have any recollection of the readings on the multimeter in that video being above 10 ohms?
I don't remember what the readings were.
Okay, so you can't say whether or not they were acceptable.
I know the test was not acceptable.
That wasn't my question. My question was, do you have a recollection as to whether or not the results on the multimeter exceeded 10 ohms?
No, ma'am, I don't.
Is it your position that the grounding of the chamber has to be checked before each treatment?
No.
She's very, very evasive in her answer because she was so clear on direct examination. Oh, this is not how you do it. But during cross-examination, very, very evasive.
When you contacted Mr. Mosteller regarding your concerns of the grounding strap, what was his response?
That they had done independent testing to show the chamber ground the patient strap was not needed. And that was their practice.
Okay. Do you know, was that the Oxford Center's practice before Mr. Mosteller came to work there?
I don't know.
Okay. Did you believe that Mr. Mosteller could override Ms. Peterson's decision on whether or not to use the grounding straps?
No.
Let me ask you something. Why do you think they didn't use the grounding straps? I mean, it was communicated to you that there was a concern about a child hurting him or herself, okay? Why do you think the grounding straps weren't used?
Objection, it calls for speculation.
On direct, she testified quite extensively about conversations that she had with Ms. Peterson, Mr. Markin regarding this. If she knows in those conversations why they didn't use the grounding straps, she can absolutely testify to that.
She testified to what she was told as the reason that they didn't use them. But I think to ask her why she thinks they didn't use it, despite what she was told, would require speculation.
Well, okay, I'll ask the question this way. Were you ever given a reason other than the fear of strangulation for not using the grounding straps?
Also told because the chambers are grounded, that the patients didn't have to be grounded. It's also shown some independent testing that showed the chambers were grounded and didn't have to have the wrist strap on.
Okay, so essentially, one, the risk of a child from strangulation. Yes?
Yes.
Okay, and their belief, based on testing, that if the chamber was grounded, then the chamber was safe.
Yes.
Okay. Did anyone ever tell you that they didn't use the straps because of cost or Ms. Peterson or someone being frugal about safety?
No.
Okay.
Still, everything about this
The
tells me
mattress is
don't treat
conductive,
kids
correct?
in these chambers.
It's grounded, so it will take electricity and essentially exited out the chamber, correct? Okay, so that's fine. You've already answered that question.
I don't have all the information on what happened to Thomas. I believe a grounding strap should have been on him.
Do you remember previously giving testimony under oath?
In Lansing?
Is that where it was?
Yeah.
Yes.
Yes, I did the deposition there, yes.
Okay. And do you recall being asked then if you could say for sure whether or not a grounding strap would have prevented Thomas's death?
I can say it would have been safer if he would have worn it. I think if I don't know exactly what happened, if there was a spark in the chamber and he was wearing the grounding strap, I think he would have had a better chance of survival.
And what is that based on?
The fire triangle, oxygen, an ignition source, and fuel. When you put those three things together inside a monoplace chamber, you create a fire.
Is it your position that without the grounding strap, there's no static in a chamber?
There's static in the chamber, but it would be rerouted out of the chamber and grounded.
But it's not rerouted through the mattress that's grounded that Thomas is laying on, that's on the grounded gurney, that's on the grounded metal rods, that's in the grounded chamber?
I can't say that indefinitely.
And do you recall when you previously testified under oath that you could not say for sure that a grounding strap would have prevented his death? Do you recall testifying to that?
I know if it, I think that a grounding strap could have prevented his death.
So are you denying that you previously testified that you couldn't say whether or not the use of a grounding strap would have prevented his death?
I don't know how his death occurred.
What?
Would seeing your testimony refresh your recollection?
Sure.
Your Honor, may I approach? 19. Started like 1.
And this is why you have depositions, because if the witness suddenly changes their mind, you can remind them, hey, you said this.
Thomas had a grounding
No,
strap.
no, no, you're just going to read it to yourself, sorry.
Okay.
And then I'll ask you questions.
What page are you at?
19. It's 19, starting at line 10.
So, it's the same thing I'm saying now.
Hold on, are you done reading it?
You're talking about this highlighted sections?
Line 10.
Grounding strap would have prevented the entire incident. I'm not so sure. It all depends, because if a reminder here, in previous hearings, there was no they tampered with the maintenance log, and one of the defendants, the technician, made his own solutions in the chamber. So in this particular, had the chamber been state of the art, everything followed every instruction, yeah, everything grounded should have prevented everything. But this particular chamber was tampered with, so we have no idea. And since we have no idea, we can assume that it was just a matter of time.
After you've read it, just indicate that you've done or you've read the portion notarized before you answer any other questions.
Now, has your memory been refreshed?
I feel the same way as I.
Okay, first just answer the question. So
Yes.
in reviewing that, was your memory refreshed to what you testified to?
Yeah.
Okay, so thank you, Your Honor. So do you now recall that when you previously testified, you said that you couldn't say with certainty that the grounding strap would have prevented the fire?
I can't say for sure.
No, the question is, now that your memory has been refreshed, do you recall that when you sat for this deposition under oath, that you testified that you could not say for sure that the grounding strap would have prevented the fire? That was, okay.
Did I say something different?
Nope. Okay, let's talk about physician supervision, okay? Is there a legal requirement that a patient have a prescription in order to receive hyperbaric treatment?
If you are billing medical insurance, I think there is a prescription and order must be in place.
Okay, great. So I think we agree. So it's really a billing concern, correct?
It is a billing concern. It's also a safety standard, just in case something happens with the patient. You want someone with a higher licensure to be able to give care to that patient.
Okay, so we're talking about two different things, okay? Is there a law that requires a patient to have a prescription to receive this treatment? Just right now, I'm just focusing on the prescription. And it sounds like what you're saying
doctors who prescribe
is that
this
there is no
shit.
law requiring it, but if you're going to bill
I
insurance,
wonder if they are
a
getting
prescription is
kickback.
required. Is that fair?
I don't know if there is a law. I know it is a standard of practice to have a prescription and an order.
You talked about a physician being present in the room while a patient receives treatment. So I just want to be clear on this. Are you saying that there is a manual or a law that requires that a doctor be present in the chamber suite? So when I say that, I mean the room where the chambers are located. It's just so that we're on the same page, okay? So is there a law or safety manual that says a physician must be present in the chamber suite?
Not in the chamber suite.
Okay.
It's not a personal supervision.
Okay. Is there a law that requires a physician to be in the building?
Yes.
Okay. Is that law also pertaining to billing? Or is it your belief that there is a law that a physician needs to be present in the building?
I believe it's a standard of care that a physician, if they're saying they're supervising the treatment, they have to be within 5 minutes directly available for anything that happens.
Where are you getting that from?
The standard of practice.
Okay, I mean, that has to exist somewhere. I mean, you don't just get standard of care out of thin air. So what book or manual, where are you getting this from that you're testifying to today?
The UHMS guidelines.
Okay, so you're saying that the UHMS guideline says that a physician must be within 5 minutes of a chamber when someone is getting treatment. That's your testimony?
5 minutes is not going to be written down somewhere, but it has to be in the facility and available.
Okay, so now you're saying that the standard of care is that a physician be in the building somewhere, and that's it?
To be available for emergencies, to clear the patients. Yes.
Okay, and that's in UHMS?
Yes.
Okay. Do you know where in the
Could be valid questions, but it tells me this is self-governed. This is not a government regulation overseen by a government body. This is themselves writing this down. And every question might be bad for this witness, but every damn question here tells me it's a fucking scam. This treatment should never be administered to kids. And any fucking doctor out there that prescribes this to kids should fucking lose their license, because you're aiding and abetting in a fucking scam. And I will fucking name you if I find out. Sue me. I would love to expose your scam ass to the world.
UHMS?
I would have to look.
Okay. You allege that Mr. Mosteller was medically clearing patients for treatment.
Yes.
Okay. Wasn't Mr. Mosteller clearing them for safety checks, not medically?
It's my understanding it was medically, that it's the same thing. Medical clearance and safety checks were cleared by Jeff and Tammy.
Didn't you say earlier that a doctor was included on these, did you call it a Teams chat? I'm not good at that. I work alone. Is that what it's called? Teams chat?
There is a Teams chat.
Okay. Didn't you testify earlier that a doctor was included?
They should be included.
No, I'm direct. Did you not testify that a doctor was included in those Teams chats?
I think a doctor was on the Teams chat.
Okay. So so everyone, if I'm understanding how this works, I mean, it's basically like a group text. Is that, okay, that I understand. So someone is sending information about a patient and everyone who's part of this chat is getting the information, correct?
Yes.
Okay. So how are you reaching the conclusion that Jeff Mosteller is medically clearing a patient when a doctor is present on that same team chat?
Jeff is the one responding that his person is cleared.
Do you know if Jeff had conversation with the doctor before responding?
I don't know.
Is it certainly possible that he did?
Yes.
Okay. So when you're saying medically clearing, okay, so let's say I'm a potential patient and I have, I don't know, a hearing aid, okay? That's something that a tech would want to double check with, like, can the hearing aid go into the chamber? That's a
Yes,
question.
A check would check that, but a hearing aid would not be allowed in the chamber.
Okay. So if I have a hearing aid and then you go on your Teams chat and say, hey, Alona wants to get treatment, but she's got a hearing aid in her left ear, and then Jeff responds and says, okay, that's fine. Clearly he wouldn't because he said it's not okay. That's what you're saying is a medical clearance?
Yes.
Okay. Even though what the question is this equipment allowed in the chamber, correct?
I see what you're differentiating. Yes.
Okay.
So it wouldn't be a medical clearance. It might be a safety clearance in that aspect.
Okay.
If it had a medical condition, then it would be a medical clearance. But if it's an equipment condition, it'd be an equipment clearance.
So do you have specific recollection of patients that had medical conditions that he cleared? Or is it possible that you're smudging those two things in your brain, a safety clearance and a medical clearance? Do you have a specific recollection of him clearing a patient who had a medical condition?
Every patient that went in the chamber had a medical condition.
Right, but there are some medical conditions that they're there just to get treatment for. They wouldn't be there unless they were getting treatment for a medical condition, correct?
They could be doing it for wellness.
Okay. Does every medical condition require clearance?
Every person that goes inside the chamber should be cleared.
Okay. And you think it was only Jeff and Tammy doing the clearances, not the doctor who was in the Teams chat?
I did not see the doctor respond.
So if the doctor didn't have a role in the clearances, why is he in the Teams chat?
I don't know.
Okay. The fact is you have no idea what conversations Mr. Mostella or Tammy could have had with a doctor prior to someone communicating the clearance, correct?
That's true.
Okay. So again, just so that I'm clear, you think there's language in the UHMS about a physician having to be present, correct?
Yes.
Okay. Now, did you ever dive patients in Troy?
I dove staff in Troy, but never patients.
Okay. So can you say with any certainty that when patients received care in the chamber at Troy that a doctor wasn't present?
I don't know of a doctor that worked in the Troy location.
You don't know of any doctor that worked in the Troy location?
No, ma'am.
Okay. Is that just because you weren't familiar with the Troy location as it operated?
I was primarily in Brighton.
Is that a yes?
Yes, I was in Brighton.
Is it possible that Troy did have a doctor and you just weren't aware of it because you didn't dive patients there?
It's possible.
Okay, let's talk about your concerns about essentially safety debriefings with clients, patients, okay? You gave some testimony on direct that it was like the people came for their treatment and there was no time to give them the safety concerns, safety measures, things that they couldn't take in. It was like 1, 2, bam, you're in the chamber, right? That was your concern.
It's concerned that there wasn't a separate consultation where they got thoroughly educated and informed on all the benefits and risks.
Okay, let me ask you something. Did you ever do a discovery appointment with a patient?
No.
Okay, do you know what that is?
Yes.
Okay, is it your testimony that those did not occur at Troy?
Discoveries did occur at Troy.
Okay, so tell me, what is a discovery?
It's like an initial consultation.
Okay, and is paperwork filled out as part of that appointment?
I don't know.
Okay, when does that appointment happen? On the day of treatment or days before treatment?
Could be either.
Could be. Do you know what it was in Thomas Cooper's case?
I don't know.
How many new patient intakes did you observe in Troy?
No.
Okay, so when you sit here and testify today that patients were not given appropriate time to meet with staff and staff didn't have appropriate time to learn about the patient and educate the patient, you have zero foundation for that allegation as to the Troy location, correct?
I've never personally experienced it in Troy. I only know that the practice was set forth by their safety director, who's over both sites.
Okay, so is it your testimony then and your assumption that because Mr. Mosteller was in charge and people at Brighton weren't doing their job, then people at Troy weren't doing their job? Is that the assumption that you're making?
I'm assuming the practice was the same at both places.
Okay. Your Honor, would you stipulate that his first state?
Okay, if you just joined, the bond violation hearing is in the beginning of this stream, the first 45 minutes. So you can, if you're only here for that one, first 45 minutes. This is the cross-examination of Tiffany Hosey, a former employee. It's a continuation of what we saw 2 days ago. So it's a continuation. She is being hammered by the defense attorneys. Hammered. But every question tells me that this site should not have been operating, treating children at all.
Treatment was December 9th.
Is that the med record? Yeah. Yeah, that's the med record.
Okay, Your Honor, there's a stipulation between the parties that that Thomas Cooper's first treatment was December 9th of 2024.
Okay, is that accurate, people?
Yeah, Judge, the date that she's getting is from the medical record of the exhibits ultimately, so.
So do you know what date Thomas Cooper first or his mother first made contact and had a discovery appointment with the Oxford Center?
No, ma'am.
Okay, Your Honor, may I approach?
I think she can certainly approach, but I'm not sure that this is the right witness to do this. She doesn't have any information about any of this. She's already said that. So I'm not sure what we're doing here. What's the relevance of this line of testimony with this witness?
Your Honor, what I think is relevant and what the prosecution has argued is that because the same people who were in charge in Brighton were in charge in Troy, then everything must have been operating the same. And that because her experience in Brighton was that they weren't doing these discovery appointments and they weren't taking time with patients, then that must be true of Troy. So these are all records provided by the prosecution that I believe are going to be admitted. And so I would like to ask the witness if she recognizes these general forms to disprove her allegation that whatever was happening in Brighton is the same as what was happening in Troy, because she has no foundation for that testimony, and there is hard copy evidence to impeach her. And if the argument's going to be made that is what's good for one is good for the other, it's absolutely relevant that she's 100% wrong.
If at the end of the day, her testimony remains that she was not involved in that process, specifically with this individual or intake in general, I don't know how she'll be able to lay a foundation as to that.
Well, respectfully, Your Honor, then how did she have the foundation to give that testimony at all? We repeatedly objected to a lack of foundation on the basis that she had no knowledge about Troy. And Your Honor allowed her to testify to it because she said it was the same people in charge, right? It's Tammy Peterson, it's Jeff Mosteller, so everything must be the same. And there is proof here, black and white on paper, that she is wrong. And I should, if Your Honor allowed the testimony, I should be allowed to impeach, or Your Honor has to strike respectfully all of that testimony.
I don't think I've heard any testimony from this witness that as she sits here today, she has been able to tell the court under oath that every single policy that has been put in place by the person that oversees in different capacities the locations, it's her belief that the policies have been the same. The information has been the same. There's not a different set of policies. I haven't heard any testimony that she's provided that every single thing that occurs at each location is exactly the same. So I think you may have relevant information to put forth for the court to consider, but she's indicated she has absolutely no personal knowledge of the interaction in Troy for intake with this particular individual. So I don't know how any of her testimony would be able to have a foundation laid for it to come in on this issue. If you want to ask her about the day-to-day practice of how she did these things, or they were done in a location where she had direct or personal knowledge, that's fine. But I feel as though you're putting something into the record that wasn't there. I had not taken her testimony to indicate that she knows with certainty that every single thing was done exactly the same way in both places.
Your Honor, I would respectfully disagree because I think argument was made by every attorney at defense table that her testimony related in any way to Troy was improper because she never worked there. Okay, so given the multiple objections from defense counsel, and then Your Honor still allowed the testimony because Ms. Hageman-Clark asked her a series of questions. Well, was it the same person who was the CEO in Brighton as it was in Troy? Was it the same safety director as it was in Brighton? It wasn't Troy. Okay, well then from that we can extrapolate that it's the same in both locations. And this is proof that whatever her experience was in Brighton is not the experience in Troy.
I hadn't taken her testimony to mean that, so I feel as though you're inferring the way the court is interpreting the testimony. But if your co-counsels would like to place something on the record that indicates that they're going along with your position, that everything she's previously testified to should be stricken, I would love to hear it.
Bueller. Judge, I from what I gleaned from the court, is that she hasn't laid any relevant evidence as it relates to the Troy apparatus and how it runs. That there was people that are common, but procedures and policy are not a foundation for which we've heard here today. So that's what I gleaned from the court. I'll leave it to the court's discretion.
I'll speak to it, is that it was my understanding on direct examination that we objected to this witness testifying as to procedures at the Troy facility because she didn't work there. Then there was a series of questions establishing that the same people were in charge of both facilities, making the leap that things were done the same at both facilities. And the witness was then able to state, based on that testimony, the inference was made that things were done at both facilities. Based on that, I believe it's totally appropriate that she be impeached upon what actually happens at the Troy facility versus her imputing what happened at the Troy facility. I think it's fair cross-examination.
She's indicated she has no knowledge about this intake or this individual, so I don't know how she can testify to these questions. But I'm not going to allow her to be questioned unless she has personal knowledge of this intake, the forms that were presented, this individual. She's clearly testified she was not there.
She can testify to forms that are specific to the center where she's employed if she recognizes them.
That's fine.
Okay.
That's not what you were asking originally. But
Well, that's what I was getting to, except that there was this objection. I never got to that
Well, I
point.
guess the issue that I'm having is that there's a lot of reference that you're making now to the named individual and a particular date of service and that person's medical records. So if she says she was not involved in any way, shape, or form in the treatment of that person or the intake process, that indicates to me she has no personal knowledge. If you have general forms that you'd like to ask her questions about, that seems like a very appropriate question.
Okay, Your Honor, I'm going to step back and then I'll reapproach the issue with the forms.
Sure.
How many intake appointments did you conduct at Brighton?
No.
How many intake appointments did you observe at Brighton?
None.
How many intake appointments did you conduct at Troy?
None.
How many intake appointments did you observe at Troy?
0.
Okay, so when you testified on direct that one of your safety concerns was that patients weren't being given education and they didn't come in for consultation prior to treatment, on what was that testimony based?
Those are 2 different things. So they were brought in for an initial evaluation called a discovery. What I was alluding to is there's no separate patient education time allotted other than right before they went inside the chamber about the safety risks and what they're supposed to be looking out for, what they're allowed to do.
If you are not present and you have never been present for a single patient intake or this discovery appointment, okay, how can you testify as to what the employee who is conducting the discovery appointment tells to the prospective patient? You've never sat in on one at either location, correct?
That's true.
You've never conducted one in either location.
No.
Okay. Have you watched one on recordings?
No.
Okay. So you have zero idea what that employee is telling the prospective patient. Is that fair?
Sure.
Okay. Now, these discovery appointments, is it your testimony that those happen on the same day of treatment?
Sometimes, yes.
Okay. So now it's sometimes, but not all the time?
Was it always the same day? Sometimes it was days later that they started treatment after the discovery.
After the discovery appointment?
Yeah.
Okay. Can you think of a single patient that you know of where discovery was conducted the same day as treatment? Or are you just guessing at this point?
I can't give a patient name necessarily, but there's definitely been a day where discovery was done. They were cleared the same day and treated on the same day.
Do you have any idea if that was the case in Thomas Cooper's case?
I don't know.
Do you have any idea the date of the first time he came in or his mother came in to do this discovery process?
I don't know.
Okay. Are you familiar with the forms that are filled out during these discovery appointments?
No.
Okay. Were nurses employed at the Troy location?
There was a nurse when I first started there. I'm trying to remember what her name was. I can't remember.
Okay, but
There was a nurse.
to your recollection, there was a nurse there, right?
Yes.
Okay. Do you know if she's the one who conducted the discovery interviews?
Yes, the nurse would do the discoveries
Okay,
in Brighton.
but you don't know what they did in Troy. Is that a no?
I don't know what they do in Troy.
Is it your belief that the practice was that the nurse reviews the discovery form and the intake form?
Yes.
Okay. You characterized, well, let me ask you this. treatment at the Brighton Center, was it your opinion that it was like one patient finishes, switch a patient, switch it? It was just like a factory. Is that your perception of treatment at the Brighton Center?
It was very busy, yes.
Okay. That characterization that you give to Brighton, do you know if that is accurate as to the Troy location?
I do not know.
Okay. How many times total have you been to the Troy facility?
I couldn't give an exact number, maybe a dozen times,
You've been there 12 times?
possibly over 4 years, yes.
For what purposes? Was it mostly to do training?
We did some research in the Troy location. When I first started at the Oxford Center, I went there just to see what it was like.
When's the last time you think you were in the Troy location?
Several years ago.
Okay, so your end date was April 2024. How much before your termination date do you think was your last visit to the Troy location?
I can't give an exact date.
How many times have you watched techs at the Troy facility care for a patient?
In person or on the video?
Let's start with in person.
No, I was not watching patients over there. I've been there when patients were being treated, but I didn't stand chamber side and operate or watch the patient be treated the entire time.
And you've already testified that you've never observed a discovery interview at Troy, correct?
No, I have not.
Okay. Have you ever observed the switchover between patients at the Troy facility?
Switch over?
Yeah, like one patient ends a treatment, the next patient goes into the same chamber.
No,
Never?
not in person.
Okay.
Ms. Sherman, could I just ask that kind of clarification?
Yeah.
Could someone explain if there is a difference, the difference between an intake and a discovery, or are these words that are used interchangeably?
I believe that they're different, but I'll ask questions about that. Okay. Is it your understanding, if you know, that the discovery appointment is different than an intake form? That the discovery form that's filled out during the discovery appointment is different than an intake form?
If I understand it right, I believe the patient is sent a bunch of documents electronically that they fill out as an intake form.
Okay.
And then when they come in as an appointment, they call that the discovery. And there's a discovery form.
Okay, so these are two different documents. One is provided directly to the patient, and you're understanding that that's the intake form, correct?
Yes.
Okay. The other is what I think you're also calling the discovery form, correct?
Yes.
And that's filled out during their in-person appointment at the facility, correct?
Correct.
Okay, and is it filled out by the patient or it's filled out by the person who's conducting the interview?
I believe it's a nurse that fills that out.
Did you want me to inquire further? Okay, thanks, Judge. Were you employed in 2020 when Mr. Mosteller gave a 40-hour class to the staff?
Depends on which month he did it.
Did he give 40-hour classes to the staff frequently?
No.
Okay. How many times do you recall him giving a 40-hour class to the staff?
He gave lots of 40-hour courses. It was not the staff that was typically the students. It was usually outside professionals and people coming in taking the course.
Were you present for any training that was for the Oxford Center staff?
I was present for several of the classes. I'm trying to recall if any of our staff were actually in the classes. I know when staff had asked to take the courses, they were given the option of watching the pre-recorded 40-hour courses on their own time.
Okay. So it was made available?
Yes.
Okay. Do you know if safety drills were conducted in Troy?
I don't know.
Okay. You assisted in these 40-hour courses, correct?
Yes.
Okay. So you were part of the training of other technicians, correct?
Oh, yes.
Okay. Were you comfortable with the training course that Mr. Mosteller had put together?
Yes.
Did you contribute to the putting together of that safety course?
Yeah. To the introductory course, not the safety course.
What's the difference?
There's a 40-hour introduction to hyperbaric medicine, and then there's a separate safety director 20-hour course that just Jeff would teach.
Okay. And you contributed to which? The 40-hour course?
40-hour course.
Okay. Do you know if the course that was given by Mr. Mosteller had received approval by UHMS for 2 years?
Initially it was, yes.
Okay. And then at some point the approval was pulled, correct?
Yes.
Okay. And that approval was pulled because there was a section on, I'll call it off-label conditions. Is that fair?
We were not presenting the off-label section because the UHMS didn't approve us to do that. So
Okay.
that was taken out of the course.
Is that what led to the course not being certified anymore?
I don't know why exactly they decided not to.
Oh, so the course that you put together was going on for 2 years and then they pulled the plug because reasons? Maybe lack of competence? We don't know.
Do it. They had asked us to create Oxford training and certification to separate the off-label use the Oxford Recovery Center was doing from the courses. They wanted it to be strictly mainstream approved indications.
And Oxford Center treats conditions that are maybe not typically thought of as being treatable by hyperbaric chambers. Is that fair?
Yes.
Okay. And you believe in those treatments?
Snake oil.
I believe there is a opportunity to treat patients that don't have the approved indications. Yeah.
Okay.
There's an opportunity. That was an interestingly formulated answer. She believes in this snake oil facility treatment and oh Jesus. Yes, Texas Annie says off-label use might cause them to pull it. Yeah. So the introductory course was for approved. So what this facility did might not even be approved of by the Hyperbaric Chamber Association or whatever it's called. And this is from the defense. So they are discrediting her. Yeah, but you're also feeding the state with a lot of information, telling them this shit that the Oxford Clinic was doing, they knew it was snake oil remedy.
Do you know if Mr. Mosteller had anything to do with the end of your time at the Oxford Center?
I don't believe it.
Let's talk about the cleaning of the chambers. Is it your statement, your testimony that the cleaning of the chambers affects the safety of the chambers?
I believe it affects the cross-contamination risk for patients.
And is it your testimony that the manual requires the chamber to be cleaned between every patient?
I don't believe it says to be cleaned between every patient.
Okay, so when you're expressing this safety concern, that's not a concern that is supported by the manual, correct?
It's more of a general infection control.
Were there a lot of wound patients at Oxford Center?
A lot is sort of vague. You mean like?
What percentage of the patients at Brighton, let's say, were coming in for treatment for open wounds?
I don't know that.
Okay. Do you believe that there are national safety standards in terms of the types of cleaning that needs to be done with the chamber?
I would follow the chamber manufacturer recommendations.
Okay, but you don't know what those are.
I know they give you specific products that are okay to use on their acrylic.
But the frequency of the cleaning?
I don't know.
Okay, and is it your testimony that at Brighton they weren't cleaning the chambers?
Not in between patients.
Okay. You talked about a safety pause prior to treatment. Is that right?
Yeah.
Okay. Is it your belief that the safety pause is in part to ensure patient identity?
Yes.
Okay. At Oxford Center, a typical treatment duration was 40 dives, correct?
Yes.
Okay, and people would come in on 40 consecutive days, correct?
It's true.
Okay, and they were often being cared for by the same tech, correct?
Yes.
Okay, so do you think after a patient completes his first 10 or 15 dives, the tech recognizes the patient and knows their name and knows that it's the right person?
Yes.
Okay, so this isn't like when you go to a hospital and the nurse doesn't know the patient from a hole in the wall, correct? There are relationships that are developed between techs and patients at a place like the Oxford Center, correct?
Absolutely.
Okay.
I work in the hospital system. We still check their armband before every treatment to be sure it's the right person.
Sure. Are you aware of any incident at the Oxford Center of either location where a patient received the incorrect treatment because they weren't identified?
I'm not aware of any.
Okay. And you believe that during the safety check, there's also supposed to be the screening of, do you have certain chemicals on your skin and so on and so forth, right?
Yes.
Okay. And it's your testimony that that did not happen at Brighton?
It did not happen every single time.
Okay.
How do you know that?
I observed it not happening.
Okay, with specific techs?
Yes.
Were certain techs less diligent about it than others?
Yes.
Okay, which techs were less diligent?
I'm going to call out their names.
Yeah.
I did not see Sheila do it. She was our lead tech. If Blake put someone in the chamber, I didn't see him doing that.
Make it a last name on Blake.
Oh, it's Oxford. Oxford. It wasn't like when you were trained to put someone in the chamber, it wasn't like you have to do the safety check. It was just get them in, get them started.
That's what you think the training was at Brighton? Yes, no?
Training was, but that's what the practice was.
Was that the practice at Troy, or you can't say?
I can't say.
Okay.
As
Is
well.
it your testimony that multiple signs were not posted at the Brighton facility advising patients about what can and cannot go into a chamber, including different substances? Shouldn't be on the skin. Substance is probably a bad word, but.
So there was a sign in the bathroom. I think there was a sign.
Okay, just one?
I can't recall the number of signs there were.
Okay. You testified earlier that textiles or fabrics in the chamber, monoplace chamber, have to be 100% cotton, correct?
Yes.
Okay. Are you not aware that the NFPA changed that standard in 2024?
To a 50-50 cotton blend.
Okay, so you are aware of that?
Mm-hmm.
Okay, so then how come earlier when you testified you insisted it had to be 100% cotton?
Because that was before 2024.
Weren't you, I don't understand. The current standard now, it's not 100% cotton, correct?
50-50 blend.
And that changed in 2024?
Okay.
Yes?
Yes.
Okay. The tech to chamber ratio. So I think we've already.
Yeah. Just for comparison, a hyperbaric chamber. Have you seen the Deadpool movie when Ryan Reynolds is put inside a chamber? It is filled with, they are pressurizing and depressurizing, removing oxygen and everything. That's a hyperbaric chamber. Now, sadly, Thomas Cooper didn't have the X gene, or so he did not develop superpowers, because it only happens in the movies. So basically, that is what happened. A chamber full of oxygen, there was a spark, and Thomas, 5 years old, who was in there for 100% oxygen. Pressurized means every lungs are filled with 100% oxygen. So when that spark happened, everything caught fire at once, including the oxygen he had in his lungs.
established that Brighton had significantly more chambers than Troy, correct?
Yes.
Troy having 3, Brighton, I think you said eventually had 8.
Yes.
Okay. Do you know what the tech to patient ratio was in Troy?
I don't know.
Okay. The only testimony that you can provide is that in your experience at Brighton, it was sometimes 2 to 8 or sometimes even 1 to 8.
Correct.
Okay. But you have no knowledge of what it was in Troy.
Only what I could see in the video.
Okay.
So generally 1 to 2 staff members were in the Troy room when I was looking at the monitors.
There were, I'm sorry, the ratio was 1 to 2, or there were, because you just said that there were 1 to 2 staff members in the room.
Right.
Okay, so there were 1 to 2 staff members in the chamber suite.
Yes.
Okay, and the most there could be receiving treatment at any time was 3 people, obviously.
Correct.
Okay. Is there any safety standard that requires the linens to read "quote unquote" hyperbaric on them in order to be safe?
No.
Okay, it's just the composition of the textile of the fabric, correct?
Correct.
Okay.
And for the question, is dive a session in the chamber? Yes. And the lingo is because hyperbaric chambers are is the thing that they treat diving sickness with. People who are they're divers, if they ascend too fast, they can get diving sickness, as in bubbles of carbon dioxide forms in the blood, can more or less explode your blood vessels from within. So it replicates diving when they pressurize down and then slowly depressurize again up to surface level. That is why they call a session in the hyperbaric chamber a dive. So it replicates diving. Nitrogen. Thank you, Texas Annie. Nitrogen. That was the word I was looking for. Thank you.
Do you know how often the chamber is supposed to be checked with a multimeter?
I'd say weekly,
What's that based on?
UHMS guidelines.
Do you know if those checks happened in Troy?
I don't know.
You talked about having concern about physicians supervising every patient. What do you mean by supervising? I guess, what was your belief that a physician had to do? What was their role?
To be in the facility in case of an emergency.
Okay, not in the chamber suite, just somewhere in the building.
Yes.
Okay. Did you ever receive training, or can you think of any safety manual that advises techs to tell patients that they shouldn't move in the chamber?
No.
Is that part of any training you've ever received?
No.
Okay. It's not in the Seacrest manual, correct?
Not that I'm aware of.
It's not in the UHMS or NFPA.
No, ma'am.
So your opinion that increased movement by a patient creates a greater risk of fire?
Yes.
Why?
Increases the static electricity.
Do you know why that's not part of any safety training or part of the Seacrest manual?
I don't know why.
But in your experience, that is not part of the typical training that a tech receives, right?
No, I've never heard of them to tell them to not move or be still. No.
Okay. Do you think it would be prudent to give that instruction to patients to move as little as possible?
In light of this, maybe, if they're not wearing a grounding strap.
You think it's fine? Do you think that static electricity isn't created if there's a grounding strap?
Static electricity can still be created.
Okay. But you just think it's less likely that there would be a fire?
Yes.
But you can't say with certainty?
I can't say that.
Okay. Are you familiar with an article, I think it's written by Steve Wood, about static electricity and how much energy is required to start a fire? You familiar with that?
No, ma'am.
Okay. Your Honor, can I approach and just ask her if seeing the article maybe jogs her memory?
Except Judge, she didn't say she didn't remember, she said she wasn't familiar with it.
But just looking at the title might jog her memory, or the book that it's from. Your Honor, it's from I only have the section title of it, but it's Fire in the Hyperbaric Environment, Chapter 3. It's an article written by Steve Wood regarding static electricity. I just have to show it to her and see if maybe just seeing it jogs her memory.
Sure. Okay.
Is that all familiar with you? Anything you came across in your training?
No, I don't believe I read this one.
Okay. When you expressed concern about not using the grounding strap, do you remember anybody ever telling you that there was a study that suggested that static electricity would not be strong enough to start a fire?
Never heard that.
Okay. Your Honor, can I have a brief moment? Yes. That's all, Your Honor. Thank you. Oh, I'm sorry. Just 1 second. I apologize, Your Honor.
You indicated that the amount of pressure in the chamber was decided by Tammy. Is that correct?
Sometimes, yes.
And other times?
Could be the physician.
Okay. And the length of treatment was decided by Tammy and Mr. Mosteller?
Those are usually decided during the discovery sessions. I don't know who exactly made the determination of how long they be treated. Or
did you ever have concerns that the amount of pressure or length of treatment was inappropriate?
No.
You were asked on direct if wrist straps had been used in every other hyperbaric facility that you had worked at, and I frankly thought you hesitated before answering yes. Was there a location that didn't use the straps?
Multi-phase chambers do not use straps.
Okay. Are they supposed to use straps?
No, ma'am.
Okay. Thank you.
All right, thank you. Okay.
Judge, can we take a 5-minute break? There's a client needs to use the facility.
Well, I think we're going to take more than a 5-minute break.
I like that idea.
I don't know what's happening. I anticipate, but I don't want to be sure that there may be other defense attorneys that have questions. So if that's the case, then I think we should just take a break for lunch and then resume.
Great.
Having you identify who will pick up questioning of this witness. Obviously, she's required to come back. Does anyone have an issue with us breaking at this time?
No.
All right. So we're going to break for lunch. You'll have to come back after we're done with lunch to resume the questioning.
Thank you, Your Honor.
Certainly.
Yeah, folks, that was part 2. Apparently, there's a part 3 of it as well. She's going to be on the stand for an additional 2 hours. This is the criminal trial. It is the state versus Tamela Peterson and 3 other employees of the Oxford Clinic of Snake Oil Scam treatment of kids that probably has no benefits to the kids. And they are charged with 2nd-degree murder. They are risking life in prison, all 4 of them. There is also a civil case. The victim's family has sued everybody involved for $100 million. And yeah, I would assume it will take a while, but my hopes are that they will be very, very successful in this, and a jury potentially will award them everything from these employees, everything from the manufacturer, everything, in a sum that basically makes them either owners of all of this or liquidate every kind of asset these fuckers have so they can't hurt any more people. Yeah, I'm slightly biased here. Folks, this is one of the few occasions, you know me, you have seen my streams before, I am very, very pro-defense. I believe in wholeheartedly in innocent until and unless proven guilty in a court of law. They are presumed innocent, but these people they hurt children. They make false hope to parents of children with needs. And they make a fuck ton of money doing it. Now, this particular witness, not a good one for the state. Not a good one. I would assume they will not call. I would not call this witness for a trial. The defense might, because she's not a good witness at all. But there are, according to the prior hearings on this, the evidentiary hearings, the state have a really good case. But yeah, I'm having a really as Gwendolyn says, I'm having a really difficult time being unbiased here, because these people are absolutely despicable. Absolutely despicable. But folks, we will continue this tomorrow. No, we will not. We will continue this Monday. Because tomorrow, Friday, no, let's see here. It's Thursday tomorrow. Oh, I'm 1 day ahead. Tomorrow, we will continue this. Thursday, we will continue this. There's another 2 hours of cross-examination and redirect. And Friday, I will do a deeper dive into the Timms case. The Timms out of Georgia. The state stole their child, claimed the child was abused, and the abuse never happened. Now, the family was acquitted at trial of all wrongdoings. The state really, really fucked up royally. So tomorrow, Friday, because even though they were acquitted, they are still out $100,000 in legal fees. So Friday fundraiser. We will go through cross-examinations of the state witnesses. And it's folks, you are going to hate the state. Absolutely hate the state. I do. So that is for Friday. So be prepared for fundraiser on Friday. The rules of engagement is as per usual. $100 to the fundraiser, $25 to me. Spin the wheel of regrets. And we have a new lineup for the wheel of regrets. We have a new lineup. Because I've been to the United States. So, lineup is a new tequila. Lineup is a new gin. Florida straight bourbon. Another bourbon. Another bourbon. There's a lot of bourbon here. It will be Sunyu. And a new vodka. Bought in Utah. 5 Wives vodka. Also, what do you call them? The sour, American sour candy. What's it called? Warheads. Yes, 8 new alcohols. And warheads. And what was this last one? It was some type of candy. I have it here, I think. Yes, hot tamales. So that will be on the new wheel of regrets. Warheads, hot tamales, and 8 new bottles of 8 new bottles of booze bought from during my trip in the United States in September. Num 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 num. So that is for Friday. Saturday, continue the reading of the Delphi trial transcripts. So that is in the near future. Folks, since I've been gone for basically a month, I need you to help me to get the algorithm to pick me up again, because my viewer count is somewhat lacking. So I really, really need you. Today, Thursday, Friday, show up. Hit the like button. Be active in chat so we can get this thing rolling. And if you like what you hear, feed the Swede. This is apparently the QR code for PayPal. And yeah, so that is in the near future. I don't have a new trial lined up yet. I have these things to get through, and then we will see what the next trial I'm diving into. All right, folks, that is what I had for you for today. So I will see you tomorrow. I hope I can start a little bit earlier tomorrow at 5 p.m. Depends on when I wake up for my nap. All right, folks. See you tomorrow, 5 p.m. Eastern Time. See ya. Bye-bye.
Sail the raven waves, brothers, axes high, shields strong. From distant lands we gather, hearts of fire all along. Obey me, cause we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free. Legends
Yeah.